Welcome to the Pop-Up Law series. Checks are a much familiar mode of transaction in India. People in business find checks as a relevant payment mode since there is a documentary proof along with it. To govern provisions relating to negotiable instruments like promissory notes, bills of exchange, and checks, the Negotiable Instrument Act was enacted in 1881. Section 138, which deals with the dishonor of check or check bounce, has been the most used and abused provision of the Negotiable Instrument Act, and time and again the Act has been amended and altered, making the law more stringent against the drawer or payer of the money to avoid fraudulent practices. In January 2018, the Negotiable Instrument Amendment Bill 2017 was put before the Lok Sabha by the Finance Minister in order to regulate and curb the increasing cases of harassment suffered by the payee in the hands of the payer. This bill received its assent from the President and it became an act on 2nd August 2018 called the Negotiable Instrument Amendment Act 2018. The new amendment added two sections, 143A, which provides power for interim compensation to the complainant, and Section 148, which provides power to the appellate court to order payment for the pending appeal against conviction. The purpose of adding these amendments was to shorten the process of granting relief to the aggrieved party and also allow them to receive interim compensation in the case of check bounce. The liabilities under the Act are, according to Section 138 of Negotiable Instrument Act, dishonor of checks is a criminal offence and is punishable with imprisonment extendable up to 2 years and with a monetary fine or both. If there is a further failure of payment within the statutory period, despite of notice served, the court may presume malice on the part of the issuer and under suspicion make the drawer liable. To secure the faith in judiciary, Section 139 was incorporated in the Act and created a mandatory presumption that a check attracting Section 138 of the Act shall create legal debt and criminal liability. Section 141 of the Act creates a vicarious liability on directors and key managerial personnel in check dishonor cases that are issued by a corporate entity, hence making every person responsible who was in charge and was involved in the management of the company's business. Recently, on 9th May 2022, in the Dilip Hariramani versus Bank of Baroda case, the Supreme Court held that a person cannot be convicted for offence of dishonor of check under Section 138 of the Act, creating a criminal liability merely because he was a partner of the firm which had taken a loan or that he stood as a guarantor to such loan. Vicarious liability under Section 141 cannot be levied upon a person merely because of the civil liabilities the individual has under the Partnership Act or any under the statute. Also, if the person can successfully establish that such offence was committed without their knowledge or the default occurred despite exercising due diligence, then such person cannot be held liable for the offence. To know more about it, please click the link below.